All right. Good afternoon, folks. We're still letting folks in, but we'll get started right in a moment. Thank you for joining this candidate forum today. This is a unique opportunity. This office only comes up for re-election every 4 years, and this year, as part of the election cycle, the Lake Champlain Chamber is coordinating a coalition of six trade associations aimed at informing our members and helping them get out and vote with confidence in their decisions. Those orgs are the Lake Champlain Chamber as a convening partner, Associated Builders and Contractors of Vermont and New Hampshire, the Burlington Business Association, the Northwest Vermont Realtors Association, as well as the South Burlington Business Association and the Vermont Retail and Grocers Association. Um, we're focusing heavily, as I said, on getting out the votes, and especially in primaries, which are very important in our region, as those are often the most competitive races or the only races in many of these positions. Certainly, that was the case the last couple times that this particular office we're discussing today has come up. Just some quick housekeeping notes. We're going to try to keep this to about an hour. It'll likely go a little bit over as these things go. Don't fret. We are recording this, and we will make that recording available shortly after. We ask you to keep yourself on mute. And if you feel that you really need to add an additional question or a comment, the chat is open. We ask you to keep it civil in the chat and on topic. And also, please understand that we have accepted questions in advance during registration. So, highly likely that we will keep within the questions that have been submitted and combined and winnowed down for time. So, one other thing I'll add is there's a lot more coming from this coalition as of next week. You'll be soon able to find our candidate questionnaires, which we've sent out to everyone in our region, as well as some early voting resources. Early voting starts on Monday, and we'll hope to push our members and inform our members how to do that. Uh, Next month, we'll have three speed networking events uh, hosted by each of the partners in this coalition, and we'll those will provide an opportunity for members to interact face to face with candidates that participated in the candidate questionnaire. So I'll put those after I'm done welcoming you all. I'll put those links in the chat as well, and we look forward to seeing you there. We've already had many of our candidates sign up for those events, and they're excited to see you all. So now I'm going to kick it off to our moderator, John Campbell, who I had the pleasure of working with when he was Senate President Pro Tem, and also got to see him work alongside the two candidates that we'll be hearing from today. John is a Vermont attorney and former Democratic state senator whose public service career spans law, legislation, criminal justice administration. He was born in Hyde Park, New York, and he earned a BS from the University of Florida and a Juris Doctorate from Nova University. And he's been licensed to practice law in both Vermont and Florida. He represented Windsor County in the Vermont Senate from 2001 to 2017, and he served as the Senate Majority Leader and later the Senate President Pro Tem from 2011 to 2017. After leaving the Senate, he became the executive director of the Vermont Department of State's Attorneys and Sheriffs, which is a department that works with both of our candidates today in support. And he held that post from 2016 until just recently in 2025 when he retired. We're really grateful to have John's expertise and insight today as we hear comments and a vision for justice in our county. I'll kick it over to you, John.
Oh, thanks, Austin. I appreciate it. And also thank you to all the groups for asking me to host this and to moderate this forum. Today we have two individuals who I've known for quite some time. I respect both of them highly. And it's a bit unique because they are both incumbents. Sarah George being incumbent for Chittenden County, the state's attorney, and Bram Kranichfeld is the current state's attorney in Franklin County. Sarah has been the Chittenden County state's attorney since 2017, and Bram has been the Franklin County state's attorney since 2023. We're going to let them introduce themselves in a second, but I did want to let you know that the questions we have, we'll pose those questions. The candidates will have 90 seconds to respond. If a rebuttal is needed, there will be some time for that. And then they'll be able to make some closing remarks. So we hope that you'll all be able to stay to the end. Again, as Austin mentioned, we're going to try to keep it to that hour. It may go over because this is an extremely important forum and very important for the candidates and also for Chittenden County. So with that, I will turn it over first to Sarah to introduce yourself.
Thank you, John. Hello, everybody. Thank you so much for having me, and thank you for being here. My name is Sarah George. I'm the Chittenden County State's Attorney. I've been a prosecutor in the Chittenden County office since 2011, about 15 and a half years, and the State's Attorney since 2017. Since being State's Attorney, I have implemented evidence-based policies and practices that highlight the inherent disparities in the legal system and seek to make our arrests, prosecution, and sentences more fair. When faced with COVID-related backlogs, which were extreme statewide, I received a national grant to fund and develop an innovative diversion program. By partnering with law enforcement and local nonprofits, we cleared nearly 300 cases by diverting repeat offenders from the courthouse and connecting them directly to substance use treatment and housing. I hired a former Burlington police officer to work in our office as a domestic violence investigator to strengthen those investigations and prosecutions to ensure better outcomes for victims. Through close collaboration with the UVM Medical Center, we have dropped violent incidents in their workplace have dropped by over 50%. We have expanded access to restorative justice, to diversion, and to our treatment courts. Through partnerships with the judiciary, law enforcement, and Howard Center, we are actively prioritizing cases involving repeat offenders by having them come to court every single Friday and working diligently to connect them directly with services, including housing, mental health, and substance use services. All of these things and much more have reduced the harm in our community while keeping people in the community, and have proven that true public safety and accountability comes from addressing the root causes of crime, meeting people's basic needs, and repairing harm to victims. I think now more than ever, Chittenden County needs a leader that has a proven track record of consistency, sound decision-making, honesty, and transparency. Thank you.
Thank you, Sarah. We'll go down to Bram.
Good morning. Thank you for having me. I'm honored to be here. I'm Bram Kranichfeld. I'm running for Chittenden County State's Attorney because I believe that we can get better outcomes from the criminal justice system in Chittenden County. Just by way of background, I've been living in Burlington for about 20 years now. For most of that time, I've been a prosecutor in various positions. I was in the Chittenden County office as a deputy for a while under TJ Donovan. I was the chief of the criminal division at the Attorney General's office. I was the executive director of the state's attorneys and sheriffs. And as John mentioned a minute ago, I am currently the Franklin County State's Attorney. I have developed an approach to the job over the years. And one of the things I believe strongly is that the state's attorney can and should represent everybody in the community in court. And take everybody into account. That means not just the people who are directly involved in a case, but everybody who's indirectly impacted by crime in our communities. I believe that any state's attorney in this state needs to strongly address the drug crisis that's been plaguing us across the state, particularly in Chittenden County. Part of that means to lean into the idea of the criminal justice system being an escalator and not a revolving door. So what I mean by that is to try to give people the tools they need to lift them up and out of the system. It also means using all the tools available to us as prosecutors to protect the public and to get good outcomes from our community. And then finally, I believe strongly that a state's attorney ought to be transparent about their policies, um, and about what kind of data we need to track in order to know if our policies are effective. I think that a state's attorney needs to be collaborative with all the other stakeholders, and especially with law enforcement agencies, without whom without a working relationship with, we can't do our jobs effectively, and they can't do their jobs effectively. Um, and I think we need to be honest about what solutions we can find in the courtroom and what solutions we need to look elsewhere for, particularly to the legislature for policy changes. So I think with all of that in mind, I think that we can get better outcomes from our system in Chittenden County, and that's why I'm running.
Thank you, Bram. Well, Sarah, the first question, it's almost like you predicted it, even though neither of you had access to any of these questions, but it's very close to what you were discussing. But I'm going to ask it anyway. What is one specific policy that you have implemented in your office to improve public safety, fairness, and accountability? And when you answer it, if you could say, tell us how, with that, how it affected both the victims and defendants in mind, how that policy affects those people. And Sarah, we'll start with you.
Sure. I mean, we've implemented a lot of policies in Chittenden County. I'm one of the only state's attorney who has written out has written out every policy, and they can be found on my website. So I would encourage people to look at them all individually. I think the policy that I am most proud of is my cash bail policy, and I know it's going to come up a lot, so I figure I'll just address it immediately. In 2020, when COVID hit, nobody was allowed to come to court. The courts were closed for over 2.5 years. People were not being required to come to court. And yet we had approximately 200 people being held on cash bail that they could not afford to pay for not coming to court, despite not being required to. The research is really clear that cash bail policy, using cash bail disproportionately impacts people of color and poor people with mental health issues and substance use issues. And that is not excluding Vermont. Vermont has that same data. And from my perspective, holding somebody in jail pre-trial when they have not been convicted of any crime simply because they cannot afford their freedom is not a product of a fair or just system. I imposed that policy because I did not believe that prosecutors should be in the business of requiring people to pay for their freedom. And it has allowed us to find other alternative ways to get people to court and to address their underlying needs in ways that have actually produced better outcomes, and people are coming to court. We do that by having them come in every Friday, particularly repeat offenders. They come into court every Friday. They see me, the same prosecutor, every Friday. They see the same judge. And we have a social worker or caseworker in the courtroom directly connecting people with services. We found that when people have a court date that is a manageable amount of time away, they have a citation date that is a manageable time away that they can deal with. And when they come in or given services, they show up. It has allowed us to resolve more cases and connect people directly with services in the community by allowing them to maintain or stay in the community.
Thanks, Sarah. You're over the 1:30, so let's, if we go, we'll move to Bram. Same question.
You know, I'm gonna I'm gonna say that a policy that I have is to approach each case on a case-by-case basis, and particularly with respect to I'm going to talk about cash bail as well. Um, I believe strongly that we as prosecutors should use all the tools available to us to get the best outcomes for our cases. I also believe that um, it's not the state's attorney's job. It's not my job to legislate for the legislature. Um, I understand that there are issues with the use of cash bail, and I believe, and what Sarah just said, I'm not going to argue with the fact that in some cases, particularly where people are under-resourced, cash bail can be inequitable. I believe that we can address those cases on a case-by-case basis. And I also think that if we decide that we want to replace cash bail as a regime with some other way to get people into court, we can and should do that, but that should be through our legislature. The responsible thing to do would be to replace cash bail with another mechanism. I don't think it is responsible for a state's attorney to unilaterally just drop out what is the only tool that we have as state's attorneys to ensure people show up in court. If people don't show up in court, then the court can't address the case. If there's no consequences for not showing up, there's no consequences in the case. I think that at best, not having a mechanism to get people into court profoundly delays the ability of the court to address these cases, to get justice for victims, to get outcomes for the community. And so again, my policy is like every other state's attorney in the state of Vermont, except for the Chittenden County state's attorney, I would address these cases on a case-by-case basis.
Okay. Sarah, any rebuttal on that?
I do just very briefly want to make sure it's very clear to everybody on here that I did not eliminate cash bail. It is still very much a tool used in our legal system, and it is a tool used in Chittenden County. Cash bail is entirely up to a judge. It is never under any circumstance up to a prosecutor. And our judges do still consider the factors that they have to consider by law and decide whether or not to impose cash bail.
Which is a perfect segue into the next question, which, again, Bram, this will go to you first. But many residents are concerned about people being arrested, released, violating their conditions of release, and then reoffending. And we know that the judges are the ones that decide what the bail is, what the conditions of their release, and the sentences. But prosecutors influence what information and recommendations reach the court and what the judge will hear. So what specific steps would you take when you're dealing with repeat offenders or repeat violators of conditions of release, and to seek accountability and protect the public and protect the public safety? And do me a favor, please distinguish if it's within the state's attorney's purview to do it, authority, or if it's up to the court, and how you would, if it is to the court, how you would influence the judge, or at least attempt to bring it to the judge's attention.
Sure. I mean, in 90 seconds, let me very quickly answer this. First of all, I believe I prioritize outcomes for our community. And I've heard from many people in our community that we have a problem with unchecked open criminal behavior in public, and with repeat offenders not apparently having any consequences. First of all, I think that again, in order for the criminal court to address a criminal case, the defendant needs to show up in court, and cash bail is our only tool to do that. My opponent is 100% correct that the judge sets bail. And also, the whole story is that the judge sets bail after hearing from both advocates in court. Judges are supposed to be neutral arbiters. They're not supposed to be putting their thumbs on the scales of justice. And I don't understand how or why a judge would give a party something that they're not asking for. If the state is not advocating strongly for the community, you better believe that the defense attorney is in there strongly advocating for their client. So I think that yes, it's true that the judge sets bail. That's also true of literally every other decision that the court makes. We as state's attorneys act as advocates for our client, which is the community. And I believe that it is incumbent on us to use all the tools available to us to get the best outcomes for our communities. That's the first part of the answer. The second part of the answer is I think that we absolutely should leverage the criminal justice system. And I can see that I'm probably running out of time, but I absolutely think that we should leverage the criminal justice system to get people the help they need, to meet them where they are. And I believe in restorative justice. I believe in diversion programs. I used to be the drug court prosecutor in Chittenden County, but these programs don't work unless there's some accountability for a participant not showing up or not participating in the program. So anyway, I can
All right.
see I'm probably out of time, John.
Yeah. Yeah. Thanks, Bram. Appreciate it. Sarah?
Yeah. During COVID, our courts were closed for over 2.5 years, and people were committing low-level offenses, and they were not being prioritized by the court. We were prioritizing violent felonies, and everything else was getting put into a backlog and pushed out. There is absolutely no doubt that the feeling that people were not being held accountable for those offenses was real. But it was real then. It is not real now. And I think it's important to make sure that we're talking about facts instead of feelings when we are talking about something so important to our community. The fact is that now what we saw, people were not coming to court again because they were committing an offense, being arrested by police, and they were giving a citation date months away. Then they were coming into court for arraignment, and they were given a court date months away. Most of these people are unhoused with severe substance use or mental health issues, and expecting them to remember a court date was impossible. So they weren't showing up for court. We did not use cash bail to fix that. I met with the court. We put our heads together, and we figured out that these people need to come into court more often. They need a court date they can remember. And when they are coming in, we need to meet them where they're at with a social worker and caseworker to address their underlying issues while they are in court. That is what we are doing now. I worked diligently with law enforcement to get them to issue shorter citations. So people are now being cited into court much quicker. When they come to court, they are being given a court date a week out at most. And they're, again, coming into the same judge, same prosecutor, same caseworker. It is not true that judges don't impose cash bail if the state is not asking for it. It might be in other counties. I don't know. I've never practiced in another county. In Chittenden County, the judges ask us what the risk of flight factors are for a particular person. We are officers of the court. We answer that. We tell them if they've missed court. We tell them what their ties are to the community. And we tell them whatever they need to know to make an informed decision. The judge then makes a decision. So it is not true that they cannot do that without us requesting cash bail. They do it every single day, all day. And they make those decisions very cautiously and cognizantly of the person that is in front of them and the law.
Okay. Sarah, Bram, do we have any rebuttal?
I guess I'll just very quickly just say, I'm not claiming that judges can't set bail without being asked for it. I'm saying that it's not appropriate. I mean, and it's not effective advocacy. If the state's attorney's office is essentially just going to drop out of advocating for that, and it's not the judge's position or responsibility to do the state's attorney's job for them. I imagine after a number of years of the policy being in effect in Chittenden County, I mean, maybe judges are in the habit of eventually just taking the reins and doing it themselves without any advocacy or motion, but that doesn't make it okay. And I'd also say that, I'm sorry. All right. Sorry.
Yeah. All right. Sarah, we're going to have this next question. We'll go for you. Should deterrence play a role in deciding whether to prosecute the lower level offenses such as shoplifting or disorderly conduct or simple assault? And if so, how would you balance that deterrence with victim protection, public confidence, and the risk of the risk that prosecution alone may not reduce the reoffense of the criminal acts?
I think I understand your question. Deterrence absolutely plays a role. It's an incredibly important piece of public safety. Research has shown that the biggest deterrent factor of repeated behavior is law enforcement showing up quickly. That has historically been a problem in Burlington when the police force shrunk, and specifically under prior leadership at Burlington Police Department, we did not have police responding to these incidents fast enough. If at all. There was actually a large number of retail thefts, disorderly conducts, unlawful trespasses that the police were never responding to. And if they did respond, it was much later. We were then, of course, like as I said before, getting these cases from law enforcement months after the incident. That is not deterrence. We need, again, it has been proven that the quicker response from law enforcement is the greatest indicator of future deterrence. And we did not have that for a long time. I know that under Chief Burke, that is being addressed much more significantly. He is doing his best, given the circumstances and resources he has, to respond to these incidents quickly and get them to our office even quicker. It is still a bit of a work in progress, but it is significantly better than it was. And I do believe that the more we can be responding to this behavior fast without these lags from incident to arrest to prosecution and to resolution, we'll have less of it happening. We'll have better outcomes for victims and therefore greater public safety.
Sarah, let me, because I believe what the person who drafted this or asked for this question to be asked, I think they were talking about deterrence, especially in dealing with people who reoffend, and whether or not the fact that if they are continually put into programs, whether it be diversion or some alternative prosecution program, what if they were, should they be prosecuted fully to the full extent, as they say, the full extent of the law, to face consequences in order to be a deterrent effect for them and for others who see what is occurring in the courts, or what they perceive to be occurring in the courts.
I guess I'm not totally sure of the question. If the question is whether or not people who commit an offense and are given some sort of diversion program and then later commit another offense, whether they should then be given, the full extent of the law as a punishment. If that's the question, I think the answer is no. I certainly believe at some point that might be the place that we get to, this sort of full extent. From my perspective, accountability is addressing the underlying causes, and the less we do that each time around, the more recidivism we're going to have. People who are incarcerated have some of the greatest recidivism rates. 98% of the people we have incarcerated will get out and are more likely to commit violence in our communities because of what they're exposed to in jail. So I think it really is a difference of how you define accountability. From my perspective, there does need to be a different outcome. There needs to be a different way of addressing a case, and there needs to be a different response to that behavior. And maybe that is a greater response depending on what the conduct is. But overall, until you have addressed the underlying needs of that person and meeting their basic needs, they are going to continue to recidivate. I mean, people commit crimes because of their basic needs not being met. So especially in these types of cases that we're talking about. So the longer we delay that, I think the longer it will take for victims to have any sort of closure and certainly any sort of restitution.
Okay, thank you. Bram, what your opinion on and your feelings about deterrence and especially dealing with reoffenders?
Sure. I mean, first of all, again, I believe very strongly that in every case, the state's attorney needs to represent the whole community. So part of that is part of this empathizing with an offender and really trying to understand what is driving the criminal behavior, what struggles they have, what their life experience has, how we can help them get the tools they need. But it also means empathizing with victims and understanding how it impacted them. And it also means empathizing with everybody else who's affected by crime. So with business owners whose livelihoods are affected, with people in recovery shouldn't have to wade through open air drug markets. So there's a scope of consideration that I think needs to be as broad as the whole community. And as far as deterrence goes, I think that, again, I strongly believe in leveraging the system to get people the help they need. I also strongly believe in accountability. And one thing I'm always asking myself in every case is, how many bites at the apple has this person gotten? And how many prior attempts have we made to try to get this person the services they need? And are they engaging or not? It goes to their culpability. It goes to the effect on the community. And I think ultimately, yes, deterrence is a very important sentencing goal. And at some point with a person's criminal record, you have to be honest about whether or not there's any hope that that this particular offender is ever going to engage in the services that are being offered them. And it's on us as state's attorneys, again, to protect the public and enforce the law. That's our core function. And deterrence absolutely has to come into play at some point. So So yeah, I don't know if that answers the question, but I guess the short answer is after a certain number of chances, I'm definitely looking for a more approach that's more balanced on the side of deterrence.
And I believe that was what the question was trying to interpret, or actually, in my interpretation of the question. But we'll move on. Ellis, Sarah, do you have a rebuttal at all? Just short, because we were kind of long going over on that one.
I do want to just make sure that the question was about repeat offenders, nonviolent offenses. But if it isn't, and you're talking about violent offenders, I want to be very clear that my office regularly asks for people who commit crimes of violence to be held without bail. So it doesn't matter what their access to wealth is. We ask the court to hold them without bail in almost every case. And the court doesn't always do that. Not often, but sometimes they do release them on conditions. But I do want to make that distinction very clear that on felony crimes of violence, our office asks for people to be held in jail.
Okay. All right. Bram, you'll get this next question. When making your charging decisions, how does your office distinguish between cases where a person primarily needs treatment, cases that need accountability, and cases that involving ongoing danger to the community?
I mean, John, every case is unique. I mean, I've been doing this for 20 years. We've done tens of thousands of cases, and I can tell you that every case has its own set of facts, right? It's why I believe so strongly in prosecutors exercising discretion on a case by case basis, because every case is different. Every case needs a different response. What am I looking at when I'm looking at a case? I'm looking at the culpability of the offender. How bad was this offense? What was the impact on the victim? What was the impact on the community? Was this a crime that was driven by some underlying issue, right? Like, was this somebody who's committing property crimes to fuel a drug habit? Is this somebody who is got an untreated mental illness? Or is this someone, for example, selling drugs for profit? You know what I mean? Like, how culpable is the person? And again, what's the record, right? How many bites at the apple has this person have? What responses have we tried before? I have a philosophy of sort of an escalating set of responses for offenders, and it's like, if it's your first offense, I'm probably sending it to diversion. I mean, depending on the case, right? If it's your 10th, 20th, 40th time around, like, at some point we gotta try some other things. So the how many bites at the apple is important, but you have to look at literally every other factor in every case in order to make the right decision. And the question in every single case is always, what does justice look like in this case? And what's the best outcome for our community?
All right, Sarah, let me just repeat the question. When making your charging decisions, how does your office distinguish between cases where a person primarily needs treatment, cases requiring accountability, or cases involving ongoing danger to the community?
Yeah, every case is different. Our office processes, so many cases every single week. When I get my cases that I've been assigned each week, I look at everyone and make a decision based on what I have in front of me. Often we are given an affidavit of probable cause from police that has the sort of basic elements of a crime outlined. It does not have a lot of additional information. After doing this as long as I have been, you can read between the lines for the most part about people who might have an underlying mental health issue or substance use issue. And at the very least, when deciding to charge, ask that they engage in pretrial services. Determining whether or not they meet criteria for Tamarack, which is an alternative diversion program for people with mental health and substance use issues, or if they're higher needs than that and you need to refer these cases through the treatment court, or if there's some alternative program. Every single case is different. Every person is different. And I think it's important to understand the humanity in each person and that their backgrounds are different, their needs are different. And in order to get what a victim might want in that case, you have to be aware of all of those things because they will come up through the litigation of the case. So if you try to figure out as much as you can, as fast as you can, so that you can come to a quick resolution that makes sense.
Okay. Bram, do you have any rebuttal or anything additional?
Can I clarify the rules? Do I have as many rebuttals as I want, or I only have the two, right?
Well, let's put it this way. I'm looking at the timer and we're doing okay on time. So I'm trying to give you all as much leeway as possible.
I mean, no, I don't on
I'm
that.
not gonna let you go forever, but I'll let you go a little bit.
No, I'm good, John. Thank you.
Okay. All right. We're at the next question. Sarah, we'll go to you. Um, Often candidates for the position of state's attorney will say that they're being tough and but they're also going to be fair. Please provide one example of when you would take a tougher approach than current practice, and one example of when you would use diversion or treatment or some other alternative to the traditional prosecution.
Sure. I mean, in 2022, we had a significant rise in violence in our communities across the state. We had a record number of homicide cases. We had in Burlington, we had 26 gunfire incidents. It was an incredibly violent year. And our office worked diligently. I myself worked diligently with Burlington Police Department and other agencies to investigate those cases, to bring us good cases, to prosecute those cases, and to ask that those people be held without bail while their cases were pending. I have very little interest in people who engage in significant violence in our communities continuing to be in our community while their case is pending. Again, that is also not entirely up to me. It's ultimately up to a judge. But that is what we did. I myself prosecuted Joseph Relazzo, who murdered his wife. I got a first-degree murder conviction on that case and asked that he get 50 years in jail, 50 years to life in jail. I previously prosecuted Stephen Burgoyne, who killed 5 teenagers, overcame an insanity defense. He got 40 years in jail, 30 years in jail. We had several other homicide cases resolved or tried in the last year, and we got very good results on those. And on the flip side of that, even for those folks, for some of them, like Aaliyah Johnson, who was shot and killed an individual on Church Street, the judge gave her 12 and a half years after a contested sentencing due to her history of trauma and other issues in the community. When it comes to diversion and other programs, as I said, I sought national grant funding from a national organization to fund an additional diversion program in our community when our courts did not have the capacity to deal with the cases. I went out of my way to apply for that. I got the money. It was over $70,000, partnered with a nonprofit to make sure that those cases could be prioritized and we could get the individuals connected to services that our court was unable to do for quite a while. That program is still ongoing. There is still some money left. It's been very successful. And the way that we are now doing our sort of new version of the accountability court every Friday is essentially, it's not a diversion. Those people are being prosecuted. They are in court every week, but we are bringing services to them. We are connecting them with services and getting much faster results for victims.
Okay. Bram, so please give us one example of when you would take a tougher stance than what might be current practice, and one example where you would use a lesser alternative such as diversion or treatment.
Sure. I mean, I think it goes without saying that on serious violent crimes, we're looking for a tough response. I think I would answer the first question by saying that we look for tough responses on drug trafficking crimes. I think that drug trafficking is driving so much of the other crime we're seeing, both in Chittenden County and in Franklin County. It's, violent crimes follow drug trafficking, and all these what we might consider lower level property crimes, like the retail thefts, and the larcenies and the forgeries and they're very, very often linked to drug trafficking. So we seek very strong responses whenever we get a drug trafficking case in Franklin County. I will always ask for a high amount of bail at arraignment for drug traffickers because they are such a risk of flight. And we work very hard with the street crimes unit up in St. Albans, which is essentially the local drug task force up there, to make sure that we have as good of a case as we can get, because we want to have a strong case, and we want to have a strong response to drug trafficking. On the other question, John, for diversion, I mean, again, we take it on a case-by-case approach. I'll say that in general, whenever I'm sending a case of diversion, I'm sending it because I think that this person does not need to get a criminal conviction, and I think that this person needs an opportunity for help, and that's what diversion does. One of the things diversion does really well is it gets people their driver's licenses back. And so one case that I almost always send to diversion are the driving without a license cases, because if a person gets their license back without getting a conviction, then hopefully we'll never see them again in criminal court, and now they get a benefit, and we all get a benefit. So that's like a category of cases I typically send a diversion. Although obviously, I hope, given what I've already said, we send a whole lot of other cases to diversion when it's appropriate.
Okay. All right. Sarah, do you have any rebuttal? If not, I'll go to the next question.
I would just note, and there is a huge difference between drug users and drug traffickers. And I think that similarly, our office takes the drug trafficker cases very seriously. We partner with our federal partners very heavily on those cases because they have a lot more tools to investigate those cases and to prosecute those cases and than we do. And we were finding in our court that we were not getting the sentences and resolutions that we thought were appropriate, and our federal partners were. So we can get cash bail on them, but most of them could post cash bail because they do have access to money. And then we weren't getting the sentences. So there was a lot of work going into them without a lot of outcome. And our federal partners do have a much better ability to hold those folks accountable.
Okay. All right. Bram, this one goes for you. We have two more questions. This and another. The state's attorney's office depends on strong relationships with police, the victims, witnesses, businesses, and service providers, and local officials. So, how would you improve coordination and trust among these groups while preserving your prosecutorial independence?
Sure. Well, first of all, let me just say that, yeah, I think it's really important for a state's attorney to have a working relationship with all the stakeholders in the criminal justice system, especially law enforcement. I'm not going to for a second argue that somehow we ought to be rubber stamping everything the police give us. We absolutely should not. We have to act as gatekeepers to the criminal justice system. We have to be a check on the police, but we also absolutely need to have a working relationship with law enforcement agencies, because if we don't have one, then we can't do our jobs, and the police can't do their jobs. So part of that, and just one thing I've been saying on this campaign a lot is, in any other state in this country, we would be called district attorneys. And I think that somehow, calling us state's attorneys is obscures what we actually do for a living. We are the chief law enforcement officers in our counties, and our job is to enforce the law and protect the public, whatever our other hats we can and should wear. I make it a priority to have a good relationship with my law enforcement agencies. I'm on the phone with my chiefs probably once a week, even if it's just to check in. If I have an issue with the way they're doing their job, I will call them, and I'll call the individual officer, and I'll call the chief to not to be antagonistic about it, but just so that we're all on the same page about how we need to put these cases together and what the best outcomes are for our communities. And I think part of that is being transparent about my policies. If I have a big ticket policy that I'm implementing, I will always include the chiefs in that conversation, and I will always make sure that we're all on the same page about what's going to happen, so that we can all work together on it. So yeah, I mean that's what I do in Franklin. I think it's an incredibly important part of the job, and frankly, I don't know how we can be effective as state's attorneys without doing that.
Okay, Sarah, again, I'll repeat the question mostly for the audience, but the state's attorney's offices depend on strong relationships with the police, the victims, witnesses, the business community, and other local officials. So, how would you improve coordination and trust among these groups while still preserving your prosecutorial independence?
Yeah, I absolutely agree. The relationship is crucial to public safety. It is crucial to doing this job. There is a narrative that my office does not have a good relationship with law enforcement, and that narrative is false. It is not. It is true that at times we disagree, and that conflict seems to be all the media cares about when it occurs. But those are the exceptions. They are very much not the rule. Chief Burke in particular, I have worked with him my entire career. He was the detective on the first homicide case that I had in that office. He then went on to become the chief in South Burlington, which needed a really good leader, and he did that. And I was thrilled when he came to Burlington, absolutely thrilled. I have a really great relationship with him. And that does not mean that we always agree. And that is the case for all of the chiefs I work with in Chittenden County. We have many law enforcement agencies. We work collaboratively with each other every single day. I have received 3 calls today from different law enforcement officers asking me questions about cases that they're investigating. Our on-call attorneys, our deputy state's attorneys call and talk to law enforcement officers every day. It is crucial to this work, and it is happening. It is not true that we do not have a working relationship with them. That being said, it is not our jobs to agree with every single thing they tell us to do. It is not our jobs um, to do anything really that they tell us to do. It is our jobs to work collaboratively with them and to have an open line of communication so that they know where we are in a case, what our opinion is on the strength of a case, what our policies are. Law enforcement are the first people I tell about our policies. They have never once been surprised by a policy that my office put in place. I go to the
Okay.
chiefs meetings regularly. I talk to them and have a great working relationship with them.
Okay. Bram, do you have any rebuttal or anything else to add to that?
Uh, I mean, I guess I think I would just say also, and this is true of, I think, all the stakeholders. If the state's attorney has like a big ticket policy that they want to implement, it's important to communicate that with everybody and to bring everybody on board. And um, and I think to set some measures of success for whatever the policy is, and maybe track some data to see whether your policy is meeting those or not. So, I think that there are a number of areas where it's really hard in Vermont to find data as to whether some of the policies that we've been talking about are working or not. And I guess I just want to say, as state's attorney, I would advocate for changes that would enable us to track data better than we're doing right now, particularly around recidivism, which I think it's really hard to know. There's very little data available.
All right. We're going to do is ask one more question, and then we'll do a wrap up we'll give you all an opportunity to close out with some remarks. And then Austin, if after that, if there are if we do have time, if there's another question that may have come in the chat, then maybe perhaps we'll be able to do that. But Sarah, we'll start with you. What would you consider to be your greatest professional failure? Or I should say error. And what did you learn from it? If you feel like you had one.
Well, I mean, of course, like prosecutors make 100 decisions a day. I am sure there are decisions I've made that had I had more time, had I had more information, had I had more background or context, I would have made a different decision. I think it would be crazy for any prosecutor to say they've done everything right. Um, Especially when I was new. I mean, the first 2.5 years I was a prosecutor, I did the domestic violence docket. I had over 300 cases of just domestic violence cases. I know there are cases that slipped through the cracks. cracks. I know that I was not able to make really good decisions on every single one of those cases. There are some of those cases I still think about of just wishing that the outcome had been different. One in particular, I even secured a conviction, but the victim ended up dying of an overdose because we didn't connect her as well or as sort of with long-term success. Yeah, prosecutors make way too many decisions. We are all asked to do too much in this system. And there are always going to be things that we cannot do to our best ability because of the sheer number of cases and limited resources that we're working with.
Bram, so what would you consider to be your greatest professional error, and what did you learn from it?
Yeah, I mean, I kind of agree with with Sarah. I mean, I've done so many cases, and I know that I know the outcomes on some of them were not what I wanted, and that I felt that it was that I made the wrong decision on, particularly around sentencing. I mean, you know, it's like we've got to make decisions on so many cases that with often with limited information, and you get it wrong sometimes. I mean, you really do, particularly when you I mean, I can think of a number of cases where I agreed to you know, maybe a more rehabilitative style sentence where somebody was out in the community and then they reoffended in a really bad way. And so, you know, it's part of the job in the sense that you have to make decisions and you've got to make the best possible decision you can make, um, given the information that you have on each case. And you really can't and shouldn't make decisions out of fear, because you're going to end up doing injustice to individuals and to the community. Um, but yeah, I mean, I think that's the best way I can answer that is, you know, you've got to approach each case and make a good faith attempt, given all the information you have, to weigh all the different factors and to really try to understand what the risks are involved in that particular case and in whatever particular sentence you're crafting for that individual. And we do get it wrong sometimes. I mean, and I do think about some of those cases myself.
All right, Sarah, anything you'd like to add before we go into the closing statements?
No, thank you.
Okay. Well, first of all, thank you very much for your candid answers in here. And I know that it's tough, and I think when you draft these answer questions, and when questions come in from the general public, sometimes they don't know the nuances of you know, your jobs, the job of the defense attorneys, the job of the judges and the judiciary, which all come into play here. So I do appreciate your answering to the best of your ability. So why don't we go ahead and start, Sarah? Why don't you start with your closing statement, and we'll wrap it up after Bram.
Thank you, John. Thank you, everybody, for coming and for listening during your lunch hour. We have made incredible progress, and we have made it through hopefully the hardest years as a community and as a state. We were devastated by COVID, a housing crisis that we are still desperately attempting to come back from. Substance use and mental health issues were exacerbated by unemployment, unaffordable health care, a lack of livable wages, and homelessness. But we are making incredible progress, and we are making that progress by being fair, by being smart, and by refusing to govern out of fear. We look at the evidence of every single issue that we face and what works, what helps to get that person back on their feet, what helps to make that person a better member of our community. And then we work overtime to work with the court to make sure that we have the tools that we need to implement that outcome. Putting people in jail for nonviolent offenses is not going to work. It is not going to get us out of this, and is actually proven time and time again to make things worse in the long run. We have to do the extra work to address people's underlying issues, and and lose the sort of narratives around law and order or being tough on crime, because it has shown over 200 years not to work. They actually increase harm in our communities. I am really committed to bringing this community together, to finding solutions that work, and to bring everybody together instead of running on any sort of divisive or dividing narrative. I really am asking everybody to continue to move forward in this work for our community, continue to be a part of a community that has a justice system that is based on evidence, based on research, based on data, and is smart, fair, and fearless. Thank you very much. I hope that you will all vote on August 11th, and I appreciate your time.
Thanks, Sarah. Appreciate it. How about Bram?
Yeah, sure. Yeah, so I mean, I guess I would just say, uh, again, I think it's important that a state's attorney is representing their constituents and is serving the community. Uh, in this campaign, I've spoken to many people in this community who feel that um, there is this unchecked criminal behavior going on in our community. There are these repeat offenders that don't seem to have any consequences. Um, I would say that uh, we're not we're not going to solve any problems by pretending that they don't exist, and we're not going to solve any problems by uh, acting like it'll just pass us by, or by doing the same thing over and over and over again and expecting different results. We have this opportunity for a change. We have an opportunity for our community to move into a more positive direction, uh, into a brighter future, and that's why I'm running in this race. And if you agree with me, if you think that that we can change, if you think that we can move into a different direction, then I hope that you come out on August 11th and make your voice heard at the Democratic primary.
Thank you, Bram. And Sarah, Bram, again, I appreciate you. I appreciate the public service that you have provided to the state and to your counties, and wish both of you luck. And also want to thank the folks that came today to listen to both of you. And I am assuming, and Austin, you can correct me if I'm wrong, but if folks have any other questions that clearly were not addressed due to the time frame, if you would submit those to the individual candidates, I'm sure that they would be happy to address them. At least I hope. I shouldn't have assumed that. But if you would like to, if you do have a question, I would urge you to submit it to those individuals. Austin, well, back to you.
Yeah, thank you, John, and thank you to our candidates for coming out today and participating in this opportunity for folks to hear from you and what is a really important position in our community as the top law enforcement officer. I want to also thank you for your years of public service already in these roles that you both have, and your long track record. Thank you, John, for your experience and expertise that you lent today as moderator, and your ability to distill for folks some of these decision points. And thank you to everyone, all the members of our coalition. That's the Associated Building Contractors, Burlington Business Association, Northwest Vermont Realtors Association, the South Burlington Business Association, the Vermont Retail and Grocers Association for helping us with this. Reminder, folks, that our primary election might be in August, but Vermont allows early voting up to 45 days before, and that actually falls this weekend. So next weekend, you can begin voting via early voting. So I dropped in the chat a link to resources for that, and you can look forward to more resources coming from the Lake Champlain Chamber and other members of this coalition, including some candidate questionnaires for House and Senate candidates, a recording of this, and much, much more next week. So if folks have any additional questions for candidates, as John said, you can always reach out to the candidates directly. You can also, if you'd like to send them my way, you can send them to advocacy@vermont.org or austin@vermont.org, and I can pass those along, as well as any other questions, comments, concerns you have. Again, thank you everyone for coming out today and spending your lunch hour with us. I'm glad we were able to do this very much within the hour time frame and not go over and respect your time. Thank you all, and hope to see you around soon.
Thanks, everyone.
Thank you.